Good afternoon to you. Today we will continue with the Constitution. In the last class, we have seen the provisions of Anti-Defection Law enacted through 52nd Amendment Act 1985, and also how the provisions have been given teeth through 91st Amendment Act 2003. These two constitutional amendments we have seen in the last class. Today we will see how the Anti-Defection Law has failed to provide adequate penal provisions against the misuse of the present law. That is, the grey areas of Anti-Defection Law we will see now. I have already told you, when we talk of the grey areas or demerits or defects or deficiencies, we should not forget that we are only examining the issue as a student. We do not claim any superiority or intelligence more than those who have framed the provisions. Now, under rules made by Parliament, under Anti-Defection Law, the Speaker can take up the question of defection only upon a receipt of a complaint from a member of the House. This is the procedure. As per the rules made by the Parliament, the question of defection can be taken up by the Speaker only on receipt of a complaint from the member of a House. Now, the member against whom the complaint has been made should be given a reasonable opportunity to explain his conduct, because the principles of natural justice demand that no person can be condemned without hearing. So obviously, before Speaker taking penal action against the person against whom the complaint has been made, the Speaker has to provide him an opportunity of oral hearing about his conduct. That is the fair procedure. That is the procedure established by law. Now, the Speaker has another option, that is to refer the case to the Committee on Privileges for inquiry and report. The committee in turn will call the person, that is the MP who defected, take his evidence and examine and then report the result of inquiry to the Speaker. So the Speaker himself will call him and take his explanation and provide him an opportunity of being heard and take a decision. This is one way. Another way is the Speaker can refer the matter to the Committee of Privileges, and the Committee of Privileges will call him, take his evidence and examine him and give its report. On the basis of the report of the Committee on Privileges, the Speaker will take the action. These are all the two methods. Now, both the above provisions, as you know, involve delay, and no immediate action is possible in both the cases. This is the point you should remember, the grey area. Number two, there is a category of members who have been expelled by the party for having disobeyed their whip. The moment the person has voted against or abstained from voting, what the political party, what is the motive, I am not saying. Motive, any motive may be. The fact remains, the political party will expel him. So once a member of parliament is expelled from the party, then what is status? So he has not been disqualified. He has voted against the whip, and because he had violated the party discipline, the party will expel him from the membership of the party. So now what is his status? According to the rulings of Lok Sabha, he is a unattached member. Unattached member. In fact, there is no provision of unattached member in Schedule 10. There is no such provision. This has been provided by the Lok Sabha. Now, what is the position of unattached member? He can participate in every discussion. He can exercise his vote also in crucial matters. So, he has the potential of voting for or against the party. So, that is the fact. Now, another issue which is which is more important is the under anti-defection law. Another issue is this anti-defection law talks about only the members of the house. Only about the members of the house. Now, a member, who is a member? The person who becomes a member only, remember, only when he takes oath of office prescribed for a member of parliament in the constitution. So he becomes the member, quote, he becomes the member of house only when he takes a oath. Now, in the event of fractured verdict, where each vote is crucial in the formation of the government, there can be horse trading, there can be mass defection from political parties, especially from smaller parties which are more vulnerable to these maneuverings. So, before the government formation, suppose before the Lok Sabha meets its first sitting and members are administered oath of office. What is the procedure? The Lok Sabha is constituted. The moment the election commission gives the details of the members, then the president will constitute the Lok Sabha and he will appoint the senior most member as the pro tem speaker. Remember, most important thing, the speaker continues in office till the reconstitution of till the house is reconstituted. The moment the house is reconstituted, President of India will appoint the senior most member as pro tem speaker. That pro tem speaker will be administered oath of office in Rashtrapati Bhavan. And this pro tem speaker will preside over the sitting. He will administer oath of office to about 10 or 15 members. And these 10 or 15 members will administer oath of office to the rest of the members. Then all members, 543 members are administered oath of office. Then the Lok Sabha is deemed to have been constituted. So, till a member is administered oath of office by the pro tem speaker or his nominee, the house is not reconstituted. So, the house is reconstituted and the member is administered oath of office. Till the oath is administered, he is not a member of the house. Kindly remember, he is not a member of the house. Now, in between, from the date of his election till he is administered oath of office, what is his status? He is not a member of the house. He is free to move from any party to another party. So, especially in the fractured verdict, where there is a possibility of government formation difficult, then in that case, the members are the horse trading will start. So, there is no provision to the spirit of the law is that he cannot defect even at this stage. But the fact may be different. So, the allurement, everything will be there. So, there is no prohibitive provisions to avoid these contingencies. So, it is high time that instead of waiting for the judicial intervention, we should anticipate such an occurrence and we should take legislative action to plug this loophole. This is another important point we should remember. Secondly, from the examination point of view, it is important to note that there is no mention of political party in any provision of the Constitution, though the political parties are formed in exercise of the powers derived from Article 19, that is, right to form union and association and cooperatives. For the first time, the 52nd Amendment Act 1985 for the first time incorporated the term political party. Most important for an examination point of view. Secondly, The term whip has also been not there in the constitution, original constitution. It was also incorporated, I mean indirectly, in class B of section 2 of 10th schedule. So, whip, that is any nominee of the political party or the representative or the nominee. So, who is the nominee? The authority is whip. So, that Lok Sabha whip or Rajya Sabha whip has been incorporated in the constitution indirectly through 52nd Amendment Act 1985. Next is, when we discuss the anti-defection law, we should see the present trend, which is very interesting and the cause of concern, cause of caution also. What is that? Now, when a defector is disqualified, kindly listen carefully. When a defector is disqualified, he contests an election again. Mostly in 4 to 6 months' time, the election is conducted. He wins the election from the party which encouraged him to defect, and in many cases, the former defector is inducted as a minister. This is absolutely permissible under the law because he has been re-elected. There is no question of any wrong in this. He was disqualified and he contests again and he is re-elected. So where is the harm? Where is the violation of the law? Nothing. Second is, in another scenario, remember, before the speaker decides on disqualification, the member resigns from the membership of the house, enabling a by-election. Contest from the party which he helped, win the election, and with impunity he becomes the minister also. This also does not violate the provisions of Schedule 10 because in both the cases, most important point, in both the cases, he is re-elected by the same people constituency. By the people of the same constituency or different constituency. However, the people have re-elected him and he become the member of the house and consequently in turn he become the member of the council of ministers. Again, does not violate any provision of the constitution. The people have condoned his defection. That is the implication. So, in both the cases, it is all fairness that he has become the minister also. Now, if you take a dispassionate view, it is not an offense to vote against the whip of the party, so long there is no malafide intention or there is no misuse of office for personal gain. The defector has only gone against the mandate of the people of his constituency. So long he is not charged with bribery or misuse of his position as member, his offence is that he flouted the trust imposed on him by his voters. Viewed in this background, it is not, you cannot presume that he has violated the law. It is but fair if he is re-elected again by the people before getting a remunerative post. It is absolutely different matter if the charge of bribery or illegal gratification is proved, in which case, in all fairness, he should be debarred for 6 years from recontesting as in the case of electoral criminal offence. Now the question is, the criminal offence, who will give the decision whether speaker is competent to decide on the culpability of a criminal offence? It is not clear. Now, see, there are so many defectors. VP Singh was a defector. Charan Singh was a defector. Devilal was a defector. Morarji Desai was a defector. And Nijalingappa was a defector. So, in all these cases, nobody suspected their integrity. The question is, when there is a lack of integrity which is doubted, their integrity is doubted, then all these things come. So, according to me, the onus should lie on the person that he had a difference of opinion with the policy of the party. He tried to change the policy. He persuaded the party to change the policy or to change the stand on a particular issue, and he failed. All these things should be in public domain. If he proves VP Singh, he had a difference of opinion with Rajiv Gandhi, so you cannot attribute any motive. There is a difference in the stand of the policy. So naturally there cannot be any doubt on them. But if a member if there is an indication, if he has not proved that his difference of opinion is based on the policy, based on the principle, based on the stand of the government or a party in a particular issue, the onus lies on him to prove that he is honest. So long he has not proved it, the implication is he has become a victim of what is called temptation. He has become a victim of allurement. That is the net. But it is for the wider wisdom of the people to decide to plug the loopholes in the anti-defection law. With this, we end the class. We will switch over to another provision in the Constitution in the next class. Thank you.